If your I-751 is pending or you need to file it in the near future and it's not pending yet, and you guys are separated and there's like no chance that your marriage is gonna work out, you're just like waiting to get your full 10-year green card before you apply for divorce, let's talk about when you should or should not file an N-400 naturalization application while you have an I-751 petition to remove the conditions on your permanent residence pending. So this is generally a good idea if you got your green card through marriage to a US citizen, you're still living with that US citizen, and your I-751 has been pending for a year or less than a year. It doesn't necessarily need to be a year, but you must have been a conditional permanent resident for at least 2 years and 9 months before you file it if you got your green card through a US citizen spouse and your US citizen spouse was a US citizen the entire time. If they became a US citizen after you became a conditional resident, then you need to wait the full 3 years. You can't apply 90 days early. So, a subtle nuance, but it actually makes a difference because I've seen people get their N-400 applications denied for prematurely applying. There's nothing in the regulations that requires that an I-751 petition to remove conditions on residency be approved before you file an N-400 application. So if you got your conditional green card through marriage, it's generally a good idea to apply for naturalization as soon as possible if you're eligible for naturalization. And if you're not sure, you should check out my other videos on this topic or schedule a consultation. My information is in the video description below. So one notable exception here. If you got married and got your green card through your spouse, but you guys are now separated or in the process of divorcing, then you might want to think twice about filing an N-400 after just 2 years and 9 months of being a conditional resident. Because when you file the N-400 application and your I-751 is pending, they're going to do a combined I-751 N-400 interview. But if you guys aren't living together, if you're separated or thinking about divorcing or in the process of divorcing, there's a decent chance that you're gonna have problems proving that you're still in a good faith marriage. Not guaranteed, depends on the situation. If you're trying to resolve the marriage actively and there's some evidence of that, that would be a notable exception to what I'm saying. But generally speaking, you only wanna do this if you're still living together in good faith as a married couple. If you've seen my other videos on the I-751 process, I talk a lot about when you should file for divorce, and here's a summary of that. Basically, if your I-751 is pending or you need to file it in the near future and it's not pending yet, and you guys are separated and there's like no chance that your marriage is gonna work out, you're just like waiting to get your full 10-year green card before you apply for divorce, I think that's a huge mistake. Because first of all, you might get a request for evidence asking for more updated evidence of your marriage, and you're not gonna have evidence of like more vacations or the juicy stuff that USCIS officers like to see. You're gonna have like generic stuff, like maybe you guys signed a new lease agreement, you got your US citizen spouse to just agree to hold off on divorce until you got your green card. I see people trying to do that all the time, and I think it's a really bad idea. Like down the road, you might have to attend a USCIS interview, and that might be several years down the road. And your US citizen spouse might not be on board with attending an interview. And even if you do attend an interview together, if you haven't been living together for the last like 1 to 3 years, because this process took way longer than you thought, there's a decent chance that the officer is gonna pick up on the fact that you guys can't tell them about your day-to-day lives together. So anyway, I think if you entered your marriage in good faith and you know for sure that this marriage isn't working out and you're gonna get divorced, I would way rather you be legally divorced than just be separated. Because if you're legally divorced, there's still a pathway where you can remove the conditions on your residency. And in that situation, I would not file the N-400 prematurely. I would wait until 4 years and 9 months of a conditional residency or full permanent residency have passed in that situation before you filed the N-400 application. If you need any assistance applying for a marriage-based green card through spouse, or you're thinking about separating or divorcing, or everything's great and you need to file the I-751 petition to remove conditions on your green card before the 2-year conditional green card expires, or you want to apply for naturalization, I'm the guy for you. My name is Puyan Darian. I'm an immigration attorney with an office in New York, and I practice these cases nationwide. In fact, most of my clients have never been in my office and don't live in New York State. So if you need any assistance, you can find my information in the video description below. You could always schedule a consultation online. It takes like 5 minutes, and I would love to speak to you about your case. If you're new to my channel and you want to stay up to date about immigration changes, or just, see things from an immigration attorney's perspective, be sure to subscribe, and I'll see you guys next time for another video.